Good afternoon, y'all. If you could put your name and the name of your organization in the chat box, we are going to be giving out certificates of participation for folks. So both for CLE credit or accreditation record, or just to frame it, put your name and the name of your organization so that we can keep track of that. And we'll give it another minute or so just to wait for everyone to go ahead and get started. All right, it looks like we've hit a critical mass of folks. So we'll go ahead and get started just to be respectful of everyone's time and because we have a lot of hypotheticals to get through as well. Welcome everyone. Please put your name and the name of your organization in the chat box for those certificates of participation. Before we get started, we do want to acknowledge that today is a difficult day for most of the communities that we are a part of and that we work with. And thank you for being here, and take care of yourselves and take care of each other. But thank you for coming. And today's presentation is the particularly serious crime presentation. My name is Lupe Perez. I'm a supervising attorney with the National Immigrant Justice Center, and my colleague is Dave Verity, also a supervising attorney.
And thanks again for joining us. Our presentation today is on particularly serious crimes and the bars to asylum, withholding of removal, and protection under the Convention Against Torture. We will we'll have a chance for questions at the end, but feel free to chat your questions to us as we go. We'll try to get to them, and if we don't get to them, we'll try to come back to them at the end of the presentation. So we are the National Immigrant Justice Center. We have offices in Chicago, Indiana, San Diego, and Washington, D.C. We are an organization dedicated to ensuring human rights and protections and access to justice for all immigrants through our combination of direct services, policy reform, impact litigation, and public education. And this presentation is brought to you by the Access to Justice Grant. And through that grant, we were able to provide trainings on working with detained immigrants to A2J sub-grantees. We also are able to conduct intakes and provide direct representation to Illinois residents through the program. So the agenda for today, we're going to start with just a brief overview of the forms of relief that we're talking about. So that's asylum, withholding of removal, and protection under the Convention Against Torture. We're then going to do an overview of the particularly serious crime bar to applying for asylum and withholding of removal. Then we'll get into specifics of the PSC bar. And there are per se PSCs, which involve aggravated felonies and everyone's favorite implementation of the categorical approach. And then we also have what are called non-per se, particularly serious crimes. And in those situations, we'll talk about the tests from the Board of Immigration Appeals in matter of Frantescu and matter of NAM. Then we'll get into Illinois-specific hypotheticals and case law, and then we'll end with questions and answers. So asylum, for those who are not familiar, we need to show for asylum applicants that individuals are a refugee within the meaning of the Immigration and Nationality Act. And what that means is that an individual has a well-founded fear of persecution perpetrated by the government or an entity that the government is unable or unwilling to control. And then that persecution has to be on account of one of these 5 grounds. So race, religion, nationality, political opinion, and the membership in a particular social group. Other requirements include that the individual cannot reasonably relocate within his or her country of origin, and also that the individual ultimately merits asylum in a favorable exercise of discretion. And there are multiple bars to asylum that could apply to applicants. One is the 1-year bar, which means that applicants have to generally apply for asylum within a year of arriving in the United States. And there are exceptions to that based on changed circumstances or extraordinary circumstances. Also, the individual cannot have been convicted of a particular serious crime in the United States, which is what we'll be talking about today. And then there are other bars, including a serious non-political crime committed outside of the United States, if that individual engaged in persecution of others or in terrorism, if the individual firmly resettled in another country, or if there is a safe third country in which that individual could relocate. And then the benefits of asylum are pretty significant. Asylees have a pathway to residency and then ultimately US citizenship. And they're also able to petition for a spouse and for their children. So withholding of removal is very similar to asylum in that individuals must still meet the definition of refugee under the INA, except the standard is slightly higher. So the individuals need to show that they face a clear probability of persecution. And so what that has been interpreted to mean is that it's more likely or not that he or she would be subject to persecution in the country of return. Now, this is a mandatory form of relief, which means that there is no discretionary element. And the applicant is technically ordered removed, but the removal is withheld. And that means that the individual can actually stay in the United States indefinitely, so long as ICE doesn't find some third country in which that person could be removed to. There are different bars to withholding of removal. Individuals who participated in the Nazi Party or in genocide, individuals who have been a persecutor, individuals who have been convicted of a PSC, which we'll talk about more. Similarly, the serious non-political crime outside the US, and if someone is deemed to be a danger to the security of the US. These would all bar those types of individuals from receiving withholding of removal. And then the final fear-based relief is the Convention Against Torture, which is a treaty convention of the United States. It's slightly different than from asylum and withholding. Has a nuanced definition, and the torture must be inflicted by or at the instigation of or with consent or acquiescence of a public official or other person acting in an official capacity. So it's different from the definition of a refugee that comes into play for asylum and withholding. Individuals must demonstrate a substantial risk that he or she will be tortured. And importantly, there are no bars to protection under the Convention Against Torture. Immigration judges must grant this relief if the applicant meets the standard. And similar to withholding, there is technically a removal order, but the removal is deferred, and ICE can seek a third country of removal. And just briefly, there are differences between a granting of withholding and protection under the Convention Against Torture. In both situations, an individual would be given an order of supervision and have to check in with ICE periodically. But the main difference is for withholding grantees, they don't have to pay for their employment authorization every year. It's free for them to apply for that. Whereas individuals who've been granted CAT protection have to pay for their employment authorization.
All right, so we're going to go into an overview of particularly serious crimes, and then we'll go into more depth for both per se particularly serious crimes and non-per se particularly serious crimes. So particularly serious crimes are defined in two separate sections of the INA, INA 208 for the definition of asylum and INA 241 for withholding. The definition does read the same, the alien having been convicted, so keep in mind that it's a conviction, by a final judgment of a particularly serious crime constitutes a danger to the community of the United States. Now, there are two types of particularly serious crimes. There are per se particularly serious crimes and non-per se particularly serious crimes. But even within per se particularly serious crimes, there are different standards, one for asylum and one for withholding. And we're going to go into a little bit more in depth as to what those constitute. And then for non-per se, as Dave already alluded to, we will not be using the categorical approach for the non-per se particularly serious crimes. Those are discretionary determinations following by a two-step analysis to make that determination. So per se particularly serious crimes. So there are two standards, one for asylum and one for withholding. So for asylum, aggravated felonies are per se particularly serious crimes. For withholding, aggravated felonies with the aggregate jail sentence of 5 or more years are per se particularly serious crimes. Now, when you're trying to determine what is an aggravated felony, or if the statute of conviction that your client was convicted of is an aggravated felony, that's when you use the categorical approach. Drug trafficking is a per se particularly serious crimes, both for asylum and withholding. Drug trafficking is an aggravated felony under the INA 101 A43. And then it's also a per se particularly serious crimes based on BIA precedent, regardless of what sentence was imposed for that conviction of that drug trafficking offense. The case that shows you this is a matter of YL. It also, drug trafficking offenses can be rebutted so that they are not a per se particularly serious crimes, and we'll go into a little bit more in depth of how you overcome that presumption, but also the factors that you take into consideration are within that case as well. So non-per se particularly serious crimes, that's a discretionary determination based on an analysis, and we'll apply that analysis, explain it, and then apply that analysis throughout the hypotheticals. But keep in mind that there are factors that you need to consider when making that argument that your client's conviction is not a non-per se particular serious crime, such as the nature of the conviction, the type of the sentence imposed, the circumstances and underlying facts of the conviction. Overall, offenses that involve the harm to others are more likely to be considered particularly serious crimes, whereas offenses that involve damage to property are less likely to be considered per se particularly serious crimes. And then you can also look at those two BIA cases, matter of NAM and matter of Francesco, for a little bit more of how the BIA applied those factors when making determinations of whether someone's conviction should be a particularly serious crime. And then just as a reminder that for this analysis, you do not use that categorical approach. So let's talk more about per se particularly serious crimes. So aggravated felonies are per se particularly serious crimes for asylum. So if someone is convicted of an aggravated felony, then they will not be eligible for asylum. Aggravated felonies with an aggregate jail sentence of 5 or more years are per se particularly serious crimes. and you can find that definition within the IN, or that statutory element within the INA 208 for asylum and 241 for withholding. So aggravated felonies. We've gone into some aggravated felonies in other presentations. There's a lot of them. Under INA 101 A43, you have each aggravated felony separated out, but also remember that catch-all aggravated felony at the end. Attempt and conspiracy to commit the substantial aggravated felony is also treated the same and is treated as someone having an aggravated felony for immigration purposes. So there are different types of aggravated felonies if it's helpful to group them. There's charge-based aggravated felonies where the sentence does not matter for what your client was convicted of. So as long as the statute of conviction meets the definition of the aggravated felony ground, then it is an aggravated felony. And this is where it gets tricky because some states punish misdemeanors could be aggravated felonies just based on the elements of the statute. Then you have your sentence-based aggravated felonies. So for those, you need to both have a 365-day imprisonment and the definition of that aggravated felony. So charge-based aggravated felonies, doesn't matter the sentence. Those can also include crimes that involve the loss of $10,000 or more as charge-based aggravated felonies, or if it's helpful to group that as a third category of aggravated felonies that involve the loss of $10,000 or more. And then you have your sentence-based aggravated felonies. So some examples of aggravated felonies that are not charge-based: murder, rape, sexual abuse of a minor, drug trafficking, firearms and explosive material offenses. Keep in mind, I believe it was that first presentation that we did where we talked about firearms offenses and the Seventh Circuit case law for making that determination if your client has been convicted of a firearms offense in Illinois. Is that an aggravated felony for immigration purposes? Then child pornography, prostitution business, peonage slavery, non-citizen smuggling, RICO and gambling offenses, and then the last two that involve the loss of over $10,000. Then for the sentence-based aggravated felonies, where you have the sentence of at least 1 year of imprisonment, keep in mind that it does not matter if that sentence was suspended or not. What was the person's sentence? Was it a 1 year of imprisonment? And then that it also falls within that definition of that aggravated felony, such as theft, burglary, receipt of stolen property, bribery, counterfeiting, forgery, obstruction of justice, perjury, crime of violence. So we're not going to go into a lot of detail of how to apply the categorical approach. We're going to give you some of that, but also our other presentations did go into a lot of detail regarding the categorical approach. So this is just for you to keep in mind that the categorical approach is used when determining whether something is an aggravated felony or not. So to determine whether a conviction constitutes an aggravated felony for those per se particularly serious crimes, you want to use the categorical approach. However, it is not applicable when determining whether a conviction is a non per se particularly serious crime. So overall, for the categorical approach, you're matching the elements of state statutes to the federal or generic definition of the criminal removable ground. So basically, is the statute of conviction for your client a match to that aggravated felony ground? Does the state punish more conduct that is not punished by the federal definition? If it does, then it is overbroad and making those arguments. And I'm going to show you the next slide, which also shows the steps that you use to apply when determining whether a conviction is an aggravated felony. And I'm not going to go into a lot of details about this, just so that we give more time to do that analysis for those particularly serious crimes during the hypotheticals. So looking and seeing what the statute says, what those definitions say. remember, it is not based on the facts of what your client did or did not do. It's based on the elements of the statute of conviction. And then matching, looking at them side by side, do they match? And then if they do, then your client is removable. If they don't, then going to that next step of the realistic probability. Is there a realistic probability that the state would punish overbroad conduct? And then going to that first step, is the statute of conviction divisible? And then applying the modified categorical approach if the statute is divisible. And then these are other factors that can help you with the divisibility analysis under Mathis. So looking at the statute, oftentimes if there's different penalties for that statute of conviction, that could be a good indicator that those are elements and not means. And then looking at the case law for those appellate cases to determine the elements versus mean questions, or looking at case law and pattern jury instructions, and then taking a peek at that record of conviction. If you want a more in-depth review of that categorical approach, I do think we have those recorded, so those are also there for you all. And then if the statute is divisible, courts can look at the record of conviction, which includes the charging document, the plea agreement, the transcript of the plea colloquy, and judgment and sentencing. But just keep in mind that not police reports could be applicable for the modified categorical approach. So for drug trafficking aggravated felonies are presumed to be a particularly serious crime, but don't forget the categorical approach is the statute of conviction, a drug trafficking aggravated offense. That's a spoiler alert for one of those hypotheticals that we will be talking about in a little bit. But then also, even if it is a drug trafficking aggravated felony for withholding and it's presumed to be a per se particularly serious crime, remember that that presumption can be rebutted by demonstrating extenuating circumstances that are both extraordinary and compelling. So how do you overcome that presumption? What are some of the facts that you can use to rebut that your client shouldn't be eligible for withholding? So Matter of YL goes into a good analysis of how to rebut that presumption, but some things to keep in mind are, what was the quantity of the controlled substance? How much was that person allegedly trafficking? What was the amount of money paid for the drugs in the transaction? Was it a collateral? How involved was the individual in that drug trafficking scheme? Were they a major player? Was it a collateral? Were they like just a smaller player in that offense? Was there violence in that offense? Were there firearms involved? Was anyone hurt during the transaction that occurred? Was organized crime and terrorist organizations involved in that drug trafficking scheme? And then also looping it to, what was your client's role in that? Was it a minor role? Was it a bigger role? And then didn't involve any adverse or harmful effects on juveniles. That one can be a little bit nebulous, but were there juveniles involved during the transaction? Anything that could be used to argue that your client was not involved in a drug, that your client was not as involved in the drug trafficking scheme in order to rebut that presumption. All right, I'm going to turn it over to Dave, but also we are going to be giving out CLE codes throughout the presentation. And those are to get that CLE credit. And your first code is particular. So when particular will be your first code, and then there will be another one coming later on during the presentation. So let me really quickly transfer this over to Dave. And then I will stop sharing my screen so that Dave can have control over the PowerPoint.
Okay, great. Okay, just one more time, the CLE code is particular. So now that we've talked about the per se PSCs, now let's talk about the non per se standard for particularly serious crimes. So this, again, we're in the non per se PSC realm when there are no per se PSCs. So when we're in this situation, there's a two-step inquiry that we need to do. The first step is looking at the elements of the actual offense. And the question is, and this comes from matter of NAM, do the elements of the offense bring it into, quote, the ambit of a particularly serious crime? And so this is almost like the categorical approach in that you're really just looking at the elements of the offense. You're not looking at the facts or the circumstances of the offense yet. And so in that first elements inquiry, if the elements do not bring it into this ambit of a PSC, then it's not a PSC. And the board has said in matter of NAM that at that point, the inquiry stops, it ceases. And there is no particularly serious crime. However, if the answer to that first question is yes, then you go to this second step, which is an inquiry into these case-specific facts. And at that point, basically, it's all reliable information is considered to determine whether your client's offense is a PSC. So this is pretty important because we think, at times immigration judges will just sort of go straight into step two when we're in this non per se analysis. But it's really important to start with step one and looking at the elements of the offense before you get into those case specific facts. And so we've talked about this a little bit before, but when we're in the non per se analysis, offenses involving harm to others are typically going to be considered particularly serious crimes. That being said, a single conviction for a non-AGFEL misdemeanor is not typically going to be considered a particularly serious crime. That being said, circumstances could definitely warrant a PSC finding, even in one of these single misdemeanor convictions. And this is really a discretionary determination at this point by the immigration judges. So really the facts and circumstances of your case are really going to matter. And these are the factors that are going to come into play under this step two of the analysis. Again, the nature of the conviction, the circumstances and underlying facts of the conviction, the type of sentence imposed, the length of the sentence, whether it was probation or not. And then it's important to know that this analysis is not subject to the categorical approach. And so what that means is basically all reliable information is going to be allowed in for the immigration judge to make this determination. So let's talk about some mitigating factors that you can bring in when you're doing this discretionary non per se PSC analysis. Just want to mention though that the board has tried to limit the ability to present these mitigating factors in cases, and so that's why we included this this question mark, because while we think it's important to make these arguments, it's not always clear whether immigration judges will actually follow those arguments in determining this PSC discretionary determination. So the first one let's talk about is rehabilitation. So the board has said in matter of RAM that an individual's potential rehabilitation is really not a significant part of an analysis of whether a crime is a PSC. And the reasoning is they sort of they have this very narrow view of PSCs as saying, well, when the crime was committed, that was a serious crime, and sort of rehabilitation after the fact, that's more of like a discretionary determination for the individual as someone's good moral character or something like that, and it has no bearing on the actual crime when it was committed. So that can be a problem, in a PSC determination. Also, the type and length of sentence imposed by the criminal court, the board has also tried to limit that as a mitigating factor in this PSC determination by saying the sentence imposed is not this sort of dominant factor in determining whether a conviction is a PSC. And the board says because these criminal courts, they look at like offender characteristics that actually that it may diminish or reduce the sentence that is actually imposed, but it doesn't diminish the gravity of the underlying crime. So it's similar to the rehabilitation arguments where they say, look, we're looking at this crime in a vacuum, and like these other things that even if the sentence imposed is not significant, that really shouldn't be dispositive as to whether the crime is a particularly serious crime or not. And so, of course, that is very frustrating because crimes that may look serious, if someone is only sentenced to probation or a very small amount of time in incarceration, clearly that is evidence, strong evidence that the offense itself is not a serious offense. But the board has basically allowed immigration judges to sort of diminish the that sort of evidence in making this PSC determination in a discretionary determination. And so also just in matter of NAM, whether the type and circumstances of the crime indicate that the individual will be a danger to the community is also a factor, and sort of something that can be used to our advantage if the crime is not a dangerous crime that could be potentially used. And then another issue we want to flag is mental health. And so there's currently a sort of a split between the BIA and circuit courts on the issue of whether an individual's mental health should be a factor that is considered when making this discretionary PSC analysis determination. And in matter of GGS, the board has said, again, in line with its past decisions on rehabilitation and length of sentence, that mental health is really not considered by the immigration court system, because that should have been considered as a factor by the criminal court system. And so it's the reasoning of the board is that why should we consider that now when it's already been considered and the sentence and the conviction has already been imposed. So that's the board's reasoning. The two circuits that have dealt with this issue to date, the 9th and the 8th, have disagreed with that assessment, basically saying that yes, like clearly an individual's mental health is relevant, especially when the standard for this PSC determination under the non-PSC standard that we're in is all reliable information. So if someone is going through a mental health crisis when he or she commits a crime, that's clearly relevant to whether that crime should be deemed particularly serious or not. So we bring this up because the 7th Circuit has yet to rule on this. We're in the 7th Circuit here in Illinois. And so this is definitely something that you should be advancing if there is indicia in your cases for your clients of some sort of mental health factor when a crime was committed. And then again, looking at this all reliable information standard, courts can look at all of these different things, including charging documents, plea agreement, transcript of plea colloquy, judgment and sentencing, and police reports. And we just want to highlight that this is not the categorical approach where if you remember from the past slides and past presentations, categorical approach, you never really look at police reports. But in this situation, anything is fair game. So police reports definitely come into play. And let's take a minute to talk about the burden of proof here, because it's actually pretty important. So because we're talking about relief, an individual applying for asylum or withholding of removal, it is the applicant's burden to show that he or she does not have, I mean, generally speaking, is not barred from asylum or from withholding. And so because the PSC bar is a factor here, each individual has to show that his or her convictions are not PSCs. And so something else that I'd like to mention, aggravated felonies come up frequently when an individual has some sort of status in the US, and DHS is trying to remove them, deport them based on the aggravated felony deportability ground. But individuals who have not been admitted or are inadmissible to the US, DHS may not actually charge convictions, offenses as aggravated felonies in an NTA. They don't have to do that. But even if they don't charge an offense as an aggravated felony, that's not sort of dispositive over whether an offense is an aggravated felony or not. You still have the burden, the applicant still has the burden to show that he or she has not been convicted of a particular serious crime. So that's really important both for the categorical approach in the aggravated felony per se PSC realm, but also in the non per se PSC situation. And we just want to bring up this recent Supreme Court case, Pereira v. Wilkinson, in which this was in the categorical approach, but it's the applicant's burden to show that his or her conviction is not an aggravated felony, even if the offense is overbroad, but it's deemed divisible. So that just shows that further highlights the fact that this is the applicant's burden to show these sorts of convictions are not aggravated felonies, but also some of the categorical approach issues can get tricky if it's sort of unclear that when the statute is divisible, but then it's unclear whether it's an aggravated felony or not. Then let's talk briefly about judicial review. So at the board level, generally speaking, the board reviews legal and discretionary determinations under de novo review. So whether an offense is an aggravated felony is a legal determination. So that's in the per se particularly serious crime realm. And then the seriousness of an offense is a discretionary determination. So again, both of those are going to be reviewed under a de novo standard. The Seventh Circuit, though, really lacks jurisdiction over discretionary determinations by the board, generally speaking. But in this context, too, the discretionary PSC determinations, the Seventh Circuit is not going to review them unless there's some sort of legal or constitutional issue that's also implicated. So that's just something to keep in mind. Okay, so now let's go into some hypotheticals. So this is a theft offense. So Abraham was convicted of theft in violation of the Illinois theft offense, 516.1. He was sentenced to a year imprisonment. And we're just going to tell you now that this is an aggravated felony theft offense because it's a theft offense and there's a year or more of imprisonment. So Abraham was Abraham pickpocketed someone's wallet on the red line during rush hour. So let me start the polls. You know what, my polling.
It may be on the top.
Yeah, it's saying polling session is inactive. While we get the polling going, the question is going to be whether you think this is a PSC or not. So start thinking about that.
And also Karen wants me to remind you all that the CLE codes are going to be needed for the certificate of participation. So make sure to fill out the survey at the end and also write down those CLE codes.
Hey, Lupe, you may need to do the polls. Can you try the polls from your end?
Sure, I think I would have to take away hosting privileges from you.
Okay.
But let me give that a try. Or you may need to give me hosting privileges. Let's see. Okay, so I am the host now. Okay, let me launch the poll. Oh, I can go ahead and launch the poll.
You can do the polls. Okay.
Okay.
Sorry, everyone.
Technological difficulties. Okay, launching that poll, and then if you want to just put your PowerPoint on full mode, that way people have that.
Okay. Sorry, Lupe. So the poll is launched. I can't see it on my end.
I have 8 out of 39 people, so we're gonna give it a couple more seconds while everyone has a chance to participate in the poll. And if you're, Dave, do you want to go back one slide? Yep.
Sorry. For
those who had not answered, that would have been very helpful. But I see that almost everyone is at, we're almost at 100% completion for the poll. So I'll give people like 5 more seconds while you have a chance to review the question once more and then enter your answer. All right. I'm going to end the polling and then show you all the results.
Okay, I can't see the poll. So can you just read the results, Lupe? Sorry. Is
this a PSC? Yes, said 57%. Yes per se PSC for asylum. 14% or 4 said yes per se PSC for withholding. 6 or 21% said yes, non per se PSC. And 3 or 11% said no, not a PSC.
Okay. Great. So yeah, so let's talk about this. So for asylum, we know that Abraham's theft is a per se PSC because it's an aggravated felony. And that's, you know, it's like pretty straightforward. Like we don't have to do any more analysis there. But for withholding, right, the per se standard is a little bit different than asylum. It has to be an aggravated felony plus that aggravated felony or felonies have to have the aggregate sentence of 5 years or more. And so we remember that Abraham's theft, he was only sentenced to a year of imprisonment. So it's not going to be the per se PSC for withholding because it's less than the 5 years. And then the only other analysis we do then is for withholding, whether it's this non per se PSC, that discretionary determination. And you know, there are definitely arguments on both sides for this. It's a discretionary determination, but you know, most likely based on the elements of the offense, that this was a theft offense, and the facts and circumstances that it was a pickpocketing situation, no one was harmed, an amount of force wasn't really necessary to commit the offense. It's probably not going to be considered a particularly serious crime for withholding purposes under this discretionary analysis. So I think this is a good example of a situation where, you know, the per se aggravated felonies does not mean, just because it's an aggravated felony does not mean it's definitely a non per se PSC. Many times that is the case, but it doesn't necessarily have to be the case. And you should definitely make arguments when you're in a situation like this, that just because it's an aggravated felony, it shouldn't be like under a discretionary analysis, a PSC. Okay, let's go to the next one. So upping the stakes a little bit here. So Mo was convicted of Illinois residential burglary for entering a home with the intent to commit a felony or theft, which is that's the elements of the Illinois residential burglary statute. And we're just going to tell you for right now, this is not an aggravated felony. This is sort of a hot topic right now in Seventh Circuit litigation, but we're going to say for right now, this is not an aggravated felony. He was also convicted of 2 counts of felony stalking, and cumulatively, he was sentenced to 5.5 years in prison for all 3 of his offenses. Also want to tell you the facts and circumstances here. Mo was under a restraining order, a no contact order. And while he was under that, he broke into his wife's home while wearing a wig. He poisoned his son's fish, and he stole some of his wife's underwear. So let's do the second poll now. So what do you think? Is this a particularly serious crime? And then is it a per se PSC for asylum, per se PSC for withholding? Is it otherwise a non per se PSC for asylum and withholding, or is this not a PSC for any of them?
We're about at halfway completion rate, so we'll give it like another 30 seconds or so.
Sure. And I'm not showing the answer this time, so might be a little harder. Sorry about that.
Looks like we've hit a plateau of answers, but I'll give a couple more seconds for folks to enter their choice.
These are anonymous as well. We forgot to mention that, so we're not going to be, grading you afterwards and giving you a score. And it's multiple choice, so it's not just one answer necessarily.
And your certificate of participation is not dependent on your answers to these polls. All right, I'm going to end the polling. So if you want to select an answer, go ahead and do so now. All right. So I'm going to share the results. 7 of the folks who answered, or 22%, said that yes, it is a per se PSC for asylum. 9 folks, or 41%, said that yes, it is a per se PSC for withholding. 10, or 45%, of the folks who answered said yes, a non per se PSC. And then 4, or 18%, of folks said no, not a PSC.
Okay, great. Thank you, Lupe. Thanks everyone for participating. So let's talk about this one. This one's maybe a little harder. Taking a step back, like all that really matters here, right, is like whether Mo was convicted of a PSC for asylum and withholding. But there are like different ways of getting there, I guess. And so one of them, the per se standard, really what we care about is whether the offense is an aggravated felony. And so if it's not an aggravated felony, it's not going to be what we call this per se PSC for either asylum or for withholding. It doesn't mean just because it's not a per se PSC doesn't mean it can still be a PSC, because there's that other discretionary determination that we do second. But in this case, because the burglary is not an aggravated felony, again, looking at the elements of the offense with the categorical approach, it cannot be this per se PSC. And so because it's not a per se PSC, that's not the end of the analysis. We still then have to, it's our burden to show, if Mo's our client, that his burglary offense is not this non-per se PSC under that discretionary analysis. When we do that discretionary analysis, we start with the elements of the offense to see whether it could be, serious enough to constitute a PSC. And if it is, then we look at the facts and circumstances. And this actually comes from a Seventh Circuit case, an unpublished case. But in that context, it was from the Wisconsin burglary. But the burglary offense is very similar to the Illinois offense that we gave. And in that case, the board and the IJ said, yeah, like looking at the elements of the offense and the facts and circumstances, which are, pretty disturbing, right? What Mo did, what he actually did in this offense, that's sufficient for the immigration judge to find that this burglary conviction is a PSC. So that's sort of how the analysis would go there. It's not a per se PSC because it's not an aggravated felony, but it would be this PSC for both asylum and withholding under that discretionary non-per se PSC analysis. Just want to mention though that in matter of Frantescu, which is from a board case from 82, it's really the first case in which the board is talking about this particularly serious crime issue. That actually was based on an Illinois burglary offense. And the offense was an intent to commit theft. And based on the facts and circumstances of that case, the board said it's not a PSC. This is sort of before the per se and non-per se distinction was in place because it predates the aggravated felony definition in the INA. But based on this, what we're now in the non-per se PSC determination, the board in that case said it was not a PSC. So I think that's definitely a case to cite to if you ever have a client with Illinois burglary, because while the statute, the offense has changed since the 80s, I think this stands for the proposition that just because it's a burglary offense doesn't mean all burglary offenses are necessarily this particularly serious crime, that based on certain circumstances, it doesn't necessarily have to be that. Okay, great. Let's go to the next hypo. Drug trafficking. Okay, so in this situation, Jesus was convicted of possession of cocaine with an intent to deliver in violation of 401(c)(2). So he was sentenced to 6 months imprisonment with 2 years probation. The actual offense criminalizes the possession of somewhere between 1 and 15 grams of cocaine with this intent to deliver. And that's classified as a class 1 felony in Illinois. The facts of the case: Jesus was arrested after he was caught selling to an undercover cop in the parking lot of a Burger King. So what do we think? Let's do another poll for hypo 3. Is this a particular serious crime? Per se PSC for asylum, per se PSC for withholding, non-per se PSC, or not a PSC?
So the poll has been launched. If you all are unable to see it or having trouble seeing the polls, let me know. But my tech skills are pretty limited, so we'll try to troubleshoot as we go. people seem to be more excited about this poll. We're almost at 50% completion, but let's give everyone like 30 more seconds to see where they're at. I think we're hitting a plateau of answers submitted, so I'll just give you all like 9 more seconds to submit those final selections. All right, ending it in 5, 3, 1. So let me share the results. We have 46% or 12 folks who said yes per se PSC for asylum, 27% or 7 who said yes per se PSC for withholding, 9 or 35 who said yes, none per se PSC, and 19% or 5 who said no, not a PSC.
Great. Thanks, Lupe. Okay, let's take a look at this one. So this one falls into that case that Lupe talked about earlier, the matter of YL, because it's a drug trafficking case. And in this case, this comes from a Seventh Circuit case, Delgado Arteaga v. Sessions. In this case, the conviction was found to be a per se PSC because Jesus had to show that the presumption, right, of a drug trafficking aggravated felony as being a per se PSC, he had to show that that presumption should not apply to him. And in that case, the Seventh Circuit and the board held that he hadn't rebutted that presumption, because there are multiple factors that that everyone has to show when this drug trafficking aggravated felony situation occurs. And in his case specifically, he didn't show that he had only this peripheral involvement in the drug trafficking conviction, that he was not connected to any organized crime. The drugs were to be distributed solely for social purposes, and that there was no adverse effect on a juvenile, as you know, in his case, he was living with a 9-year-old child. I think this is an important case because it shows, like, the facts of this case was he tried to sell some cocaine to an undercover cop in a Burger King parking lot, and he seemed like a pretty low-level offense in terms of drug trafficking, but it's really our burden as advocates to show in these situations all of the factors of YL, because otherwise, the courts will come down hard on our clients for not meeting those factors. That's sort of the answer for this. However, we have another hypo because there's been an update, and that is another Seventh Circuit case, United States v. Ruth. Now, those who participated in our first A2J training a few months back on drugs and guns may remember this case. But this is it's a categorical approach argument as to whether cocaine, the definition of cocaine under Illinois law, is broader than the definition of cocaine under federal law, which is important for the categorical match of the two offenses. And so Seventh Circuit and Ruth said, no, cocaine is actually broader than the federal drug schedules, because it includes positional isomers of cocaine. And so it also held, in addition to that overbreadth, that 401c2 is not divisible as to controlled substance. So basically what that means then is this Illinois dealing in cocaine under 401 C2 is not this aggravated felony drug trafficking offense because of its overbreadth and the fact that it's not divisible as to these overbroad substances. So follow-up question, does this change your previous answer as to the particularly serious crime?
The polling is launched, so go ahead and enter your answers.
And the questions are, if I can remember correctly, can you read the questions again? Sorry, Lupe.
Is this a PSC? Yes, presumptively a PSC under YL. Yes, non-per se PSC. No, not a PSC. So we'll give you guys like another 45 seconds to respond. And the drug in the hypothetical was cocaine, correct?
Yes, the hypothetical was it was cocaine and he tried to sell it to an undercover cop in the parking lot of a Burger King.
Okay, we're reaching a plateau, but let's give you all like 20 more seconds to answer that. All right, go ahead and enter your final answer and I'll end it right about now. So share the results. And then, is this a PSC? 5 or 24% said yes, presumptively a PSC under YL. 38% or 8 folks said yes, non-per se PSC. 43% said, or 9, said no, not a PSC.
Great. Awesome. Okay. Thank you, everyone. So let's take a look at this. So I think most of you picked up on this, that the YL presumption of the per se PSC really, I mean, technically, it should only apply to aggravated felonies involving the unlawful trafficking in controlled substances. So if this is not an ag fel, right, under United States v. Ruth, then technically that YL presumption should not apply. And so we can't, it's not necessarily a per se PSC because of that, because it's not an aggravated felony and it's this YL presumption doesn't apply. That being said, the non-per se analysis, I think this is going to be difficult. So, you know, I think a lot of immigration judges are going to see the fact that this isn't an aggravated felony as sort of a technicality, because we're talking about the overbreadth of isomers of cocaine. And so it's probably going to be difficult unless you have very compelling facts and circumstances. It's probably going to be difficult to show that this is not a non-per se PSC, because drug trafficking offenses clearly, I mean, even if it's not technically an aggravated felony, clearly the board and the attorney general are not fond of drug trafficking offenses and really, you know, want them to bar these types of relief. So definitely something to argue and to not concede at any point, but that's sort of how this is going to function. You know, the more drug trafficking and drug offenses that are determined to be overbroad and not aggravated felonies, the more this issue is going to come up. So great job, everyone. Let's go to the next hypo and we'll transition over to Lupe. But before we do, let's give our second CLE code. Second CLE code is going to be BARS, B-A-R-S, as in the PSC bar. So BARS.
And just a reminder, everyone will need to enter the codes in order to receive that certificate of participation. And you can use that. And that certificate of participation is available for everyone, those who want CLE credit and those who do not need CLE credit or want CLE credit. So the fourth hypothetical, Ali was convicted of aggravated battery for causing great bodily harm or permanent disability or disfigurement under that Illinois law. He was sentenced to 7 years of probation. However, we're letting you know that this is not an aggravated felony because he was not sentenced to a year of imprisonment. And for a crime of violence, you need that 1 year of imprisonment in order for it to be an aggravated felony. Some of the facts of the case: Ali was involved in an altercation with a man in which Ali produced a box cutter and cut the man in the chest, face, hand, and shoulder. As he was doing so, Ali stated, "I will kill you." After fleeing to the United States, Ali suffered from nightmares because he entered as a refugee from Somalia, but while in Somalia, he witnessed and experienced atrocities, including his sister's murder. Because of what he witnessed while in the United States, he developed a drinking problem and struggled with PTSD, depression, and insomnia. So I'm going to launch the poll for this one. And then, is this a particularly serious crime? Yes, per se, particularly serious crime for asylum. Yes, per se, particularly serious crime for withholding. Yes, non per se, particularly serious crime. And no, not a particularly serious crime. And for those who are saying that this is not a particularly serious crime, and even for those who are saying, yes, this is a non per se particularly serious crime, what factors are you using to make that determination? So what would you be arguing for that? And then the CLE codes were particular and bars. Spoiler alert, they're also in the chat of the presentation. So we are about 50%, so let's give you all another 30 seconds to make that analysis. Okay, I think we're almost there. So just a couple more, just like 15 more seconds so that everyone can enter their final answers. Okay, so I'm going to end the polling and share the results with you all. So 22%, or 5 of you, said yes, this is a per se particularly serious crime for asylum. 30% of you, or 7 of you, said that yes, this is a per se particularly serious crime for withholding. 12 or 52% of you said it was a non per se particularly serious crime. And then 3 of you, or 13%, said no, not a particularly serious crime. So let's take a look at the answer slide and go into this a little bit more. So this is actually based on the Seventh Circuit case. However, instead of the Illinois statute, it was based on the Wisconsin substantial battery with the intent to cause substantially bodily harm with the use of a dangerous weapon. So that in this case, the Seventh Circuit did defer to the BIA finding that Ali's conviction was a non-per se particularly serious crime. So a couple of things to note here. It is not a per se particularly serious crime for asylum because it's not an aggravated felony, right? So it's not an aggravated felony because that bodily injury would be a crime of violence. And in order for a crime of violence to be an aggravated felony, you need that term of imprisonment for a year. So it's not an aggravated felony. So as such, it is not a per se particularly serious crime for asylum. It's not a per se particularly serious crime for withholding. We didn't give you if Ali had any other convictions or if he had any other criminal history, but also remember that in order for withholding purposes, for it to be an per se particularly serious crime, you have to have that aggregate sentence of 5+ years. So then we go into non-per se territory. And it's important to note here that Ali argued with the Seventh Circuit that PSCs must be aggravated felonies, and the court rejected this argument. So even though something is not an aggravated felony, for example, it could be a CIMT or a crime involving moral turpitude, it could still be a non-per se particularly serious crime. So crimes involving moral turpitude can still have dire consequences for protection-based relief. So as such, we go into that non-per se analysis, right? The first step, does it fall within the ambit of particularly serious crime offenses? And, unfortunately for Ali, this crime, particularly offenses that involve injury to people, are more likely to be found to be particularly serious crimes. Then we go into the factors of the case in order to determine if Ali's conviction would still be a non-per se particularly serious crime. For those of you who said that it was non-per se particularly serious crime, what were some of the arguments or what were some of the reasonings that you were employing to make that determination? Or now that I say that it is a non-per se particularly serious crime, what would be some of those factors? Thinking back to Dave's mitigating factors. I think looking at the injury, did that person ended up in the hospital? What was their level of injury? The sentencing of Ali, he didn't actually get sentenced for any jail time. There were no mental health arguments raised in the Seventh Circuit for his case. And even though the BIA has said that mental health should not be considered during the duration or for a determination of a non-per se particularly serious crime, still preserving those arguments and using those arguments to argue that Ali was not convicted, that Ali does not have a non-per se particularly serious crime. So let's enter that next hypothetical. Okay, so it's a sexual abuse offense. Walter was convicted of aggravated criminal sexual abuse under Illinois law based on an act of sexual conduct with a victim who is under 18 years of age and the person is a family member. He was sentenced to 3 years of probation. And the facts of the case or the plea agreement said that the victim was 7 years old at the time of the offense. Walter's indictment stated that he fondled the victim's leg for his own sexual gratification. So let me share that. Let me launch the poll for this hypothetical. Is this a particularly serious crime? Yes, per se particularly serious crime for asylum. Yes, per se particularly serious crime for withholding. Yes, non per se particularly serious crime, or no, not a particularly serious crime. So I'll give you guys like a minute, or I'll give you all a minute to select your answers. And as you guys are selecting the answers, couple of housekeeping matters. You should have entered your name and the name of your organization in the chat so that we can match that with the survey that we're going to send out at the end of this presentation. And then in that survey, there will be those spaces for those codes. And then once we get the survey, once we receive your survey, then you will receive those certificates of participation. All right, so we're over half of people answering. So let's just wait 10 more seconds and then I can launch the answer for this poll. Okay. So sharing the results, 14 of you are 58% yes per se particularly serious crime for asylum. Yes per se particularly serious crime for withholding. Yes non per se particularly serious crime worth 11 or 46, 11 folks or 46%. And then 2 or 8% said no, not a particularly serious crime. So let's take a look at this one. This one is based on a Seventh Circuit case where the BIA did hold that the offense was a sexual abuse of a minor aggravated felony. And then remember that for sexual abuse of a minor aggravated felonies, those are aggravated felonies without their charge type of aggravated felony. So the sentencing does not actually matter for those aggravated felonies. So this case, they also held that it was a particularly serious crime for withholding because crimes of sexual abuse against children involve a heightened risk of violence and because of who the minor involved was. It was his daughter, so the Seventh Circuit case reasoned that Walter violated his daughter's trust. However, this was before Esquivel-Quintana versus Sessions, and as we've talked in other presentations, that an age discrepancy of statutes that involved minor children who don't distinguish between those who are 16 versus 18 has eroded that sexual abuse of a minor territory. So as such, this would probably not be categorically a sexual abuse of a minor aggravated felony per se, but then you enter in that non per se territory to determine and to do that analysis if this is a non per se particularly serious crime. So entering into that analysis of what were the facts of that case. Well, first you would go through that first step of whether it falls within the ambit of a particularly serious crime, and then does it involve, what are the facts surrounding this case such that your client would not have a non per se particularly serious crime. All right. I do want to leave some room for questions, and we just have a couple of more slides. So Keep in mind that the particularly serious crime bar is only triggered by convictions, not pending charges. And then asylum is discretionary. So for example, pending charges are relevant to whether an applicant merits relief. And then pending charges have no effect on withholding and CATs, because withholding and CATs, as Dave was explaining, are mandatory forms of relief. And then this rule was enjoined. So the previous administration did draft new criminal bars to asylum eligibility. And that was supposed to go into effect on November 20th, 2020. However, it was enjoined by the Northern District, but these are some of the new criminal bars that the rule created. Any felony, 2 or more DUIs, domestic violence offenses, smuggling or harboring convictions, illegal re-entry convictions, misdemeanor unlawful possession or use of IDs, misdemeanor unlawful receipt of public benefits, and misdemeanor possession or trafficking of controlled substance. Those were supposed to go into effect, however, they are not in effect as of right now, but just something to consider, something to keep an eye on in the future. And I saw, okay, so takeaways. So for aggravated felonies, remember to do that categorical approach analysis in order to determine if your client's conviction is an aggravated felony and as such a per se particularly serious crime. And although offenses that are not aggravated, although offenses that are aggravated felonies are particularly serious crimes, offenses that are not aggravated felonies can still be PSCs. And always go through the 2-step analysis for those non-per se particularly serious crime. 1, does it fall within the ambit of a particularly serious crime? And then if it doesn't, or if it does, then go into that 2nd step. And although the Board of Immigration Appeals has tried to erode that mental health situation should not be considered, always still incorporate those arguments because the 7th Circuit has yet to rule on those. And then there were
Great. There are a couple of questions that came in towards the end, Lupe. One of them is people are raising good points about the sexual abuse of a minor offense and how it may not be a categorical match, but like there still could be enough there for that aggravated felony ground. We just wanted to introduce that because just because something has been settled to be an aggravated felony in the past, and you'll find these in PSC cases that analyze the AgFel provisions, don't just necessarily take that as settled law, because this is a dynamic area of the law, especially cases that predate Mathis, which is sort of the most important case right now on the categorical approach and divisibility. So there could be arguments there for aggravated felonies, but even in that case that Lupe presented, if the offense is still determined to be a non-per se particular serious crime, sort of whether it's an aggravated felony or not may not even have much of an effect, because it's the immigration judge is still going to find that it's going to be a PSC regardless of it not being a per se PSC. But just something to keep in mind that there could be arguments as to categorical overbreadth. I think there was another question too about the, I believe it was about the drug trafficking offense. So the first version, when we said it was an aggravated felony drug trafficking offense, so in that scenario, then we know it's definitely, and because it's an aggravated felony, it's definitely a per se PSC for asylum. And so the YL factors really come in more for the withholding category, whether it's a per se PSC for withholding. And the idea there is that, remember, like aggravated felonies typically need to have a sentence of 5 or more years to be a PSC, a per se PSC for withholding. But there's an exception for drug trafficking crimes. drug trafficking aggravated felonies, they don't have to have that sentence of 5 or more years because they're presumed to be PSCs, and then that's where applicants have to rebut that presumption. So that, I don't think that was clear in the slide, so I'm sorry about that. But that's, again, in the aggravated felony drug trafficking portion.
Any other questions? I think we have like a couple minutes. Let's see.
Okay, so here's a question. How often, or is it possible for non-charged activity to tip the scale and result in a finding that a particularly serious crime conviction or a particular crime conviction is a non-per se PSC where, where it would otherwise not have been found to be a PSC, but for the non-charged conduct stemming from the same incident? Yeah, so I think the basic concept here is that like you're looking at conduct in like a police report or something. It doesn't actually get charged as an offense, but like it's still the background here. I think, again, if you're in that non-per se PSC analysis, any reliable information is going to be admissible. So, you know, yeah, if another situation could be like if someone's charged with like 4 different counts of something and 3 of them are dismissed and only 1 of them is actually pled to, and the dismissed counts, you know, look bad and there's sort of worse activity, I think that could still sort of come into play if it's sort of in the same area as the actual conviction. So, I mean, you can make arguments that that information is not reliable, but I think there's just broad discretion here in terms of, you know, what constitutes a non-per se PSC.
We have another question about handling PSCs at USCIS, for example, when applying for an EAD for someone with a pending asylum application at court. So I think we would still want to know if it was a conviction for those purposes, and then making the arguments as well for particularly serious crimes. Anyone else have any other questions? All right.
Okay, well, yeah. If you have any other questions, feel free to contact us. And you know, this is our last, this is our 4th and final presentation of the fiscal year. So thank you to all of you who've been to all 4 of them. Thank you for coming, and thank you for coming today as well. We really enjoyed doing this, and we hope to continue to be able to do this in the future.
And keep your eye out for the survey.